real pleasure now to be joined by somebody who probably knows more about criminal laws and what needs to be done to fix them than anybody else in the country. One of the top criminal lawyers we have in the nation, Sidharth Luthra. Sidharth, it's a great pleasure to, of course, speak to you. And while, of course, a lot of analysis will happen on the new laws and lots of discussion in the standing committee on what needs to be fixed, I guess to start off with, it has to be said that it's a cause of some celebration that a coherent, big, massive exercise is actually being done to try and reform criminal laws in India, because God knows it was long overdue.
So I'll tell you, Vikram, there are two parts which we have to consider this in. The first is there an attempt to reform the law? And I would say definitely there is. Is there an attempt to update the laws? Yes, there is. But having said that, the core of the penal code, which essentially is a law in 34 countries even today, and other countries have also played around with the sections, modified it, fine-tuned it, added provisions as we had in the past, is an exercise which needed to be undertaken because there were a lot of things in the existing code which needed updation. It's, after all, as you said, 160 years old. Having said that, what we must also understand is that if we wish to make a break from the colonial past, then are our laws liberty-oriented? Because the Constitution talks about Article 21. So are these laws regressive or liberty-oriented? And if you look at that, there are some issues where you see a lot of light. For example, community service is now a punishment, which is a very important move, according to me, because it takes the load off the prison system and makes an alternative sentencing possible other than a custodial sentence. That's a very important way forward. It's been done by courts on occasion, but that's only as an ad hoc arrangement, nothing, and that too under the constitutional powers of the Supreme Court. Having said that, what is important for us to see is, while we have added this provision, have we tinkered with one of the most important things, which is, have we expanded the scope of plea bargaining? Have we, like in the US, introduced offense bargaining? That is to say, a person who's accused of murder can plead guilty to a lesser offense, let's say grievous hurt or culpable homicide, and be given a sentence, but he or she is out of the system. So you reduce that many cases, which go through the gamut of appellate challenges. So these are issues which, according to me, it's a great effort made, but there's a lot more that has to be done.
I think you're absolutely correct. But the point I think which we should keep in mind is that now that these three bills have been introduced, there is going to be a process of debate, of change, of standing committee brought to Parliament, hopefully a lot of discussion. Experts like yourself and others will also come and give their further views. There'll be public discussion. And hopefully whatever changes you're suggesting will also be made. And hopefully at the end of the entire process, we will have moved towards greater individual freedom and individual liberty.
Yes, of course. There can be two stages which there can be amendments. One, the standing committee would look into the various provisions. There is also a likelihood that in this matter, hopefully, I think this will go to a JPC. And finally, Parliament has the opportunity to amend the provisions. They're not bound by what the standing committee says. They will take that into consideration, but they can enact the provisions with changes. And we are hoping that our legislators will have a meaningful, comprehensive debate. Please remember one thing. What is the CRPC, the Criminal Procedure Code, which existed and which is now replaced by new law? It is essentially Article 21, our right to life and liberty in action. For the ordinary citizen in the street, what makes a difference is, can the police arrest me? Can the police question me? Can the police put me to detention? Can I be asked to confess? And that is the CRPC. And that is, as I would say, Article 21 in action.
Mr. Luthra, you're absolutely correct. And that's exactly why this is such an important process. Because at the end of the day, if we are living in a free country and we've been celebrating Independence Day, as the citizens of a free country, you should have the ability to live as a free individual, where a state can't just come and take away your liberty or your freedom without a lot of things happening. So I'm just going to come to 2 or 3 specific points that we were just talking about. and which have not just now, for decades, a lot of these things haven't actually worked very well. So let's try and see how those can potentially be fixed. First of all, the power of arrest, the entire question of bail, the concept of bail and not jail. Now, these are things that we've been debating, I don't know, since I began my journalism career, 30 years or so, we've been discussing many of these issues. Are we anywhere closer in these bills to getting better systems where you can't just be arrested and thrown into prison and kept as an under trial for 5 years, 7 years, 10 years, and then finally somebody says, oh yeah, you're actually fine, you're acquitted, go home?
So I'll tell you, there's a problem that is now foreseen as a result of these amendments. The bail provisions, the arrest provisions have really not been changed. And despite the Supreme Court in 94, in 97, again in 2022, coming down strongly in Antil's case, the government has not brought out a special bail act, which was something which we hope will come at some point of time. It would have been wonderful if it had come in this amendment. We had an era in the 1970s and 80s where we had a liberty-oriented jurisprudence coming from the Supreme Court, where bail was the rule, jail was an exception. In the 1990s, post-liberalization, that changed. And while there have been attempts to have it liberty-oriented, we must remember that there are different views that emanate from the Supreme Court, depending on at different points of time, because benches do not sit as one, they sit in separate benches of 2s and 3s. So there is sometimes variation in the view towards liberty. Having said that, what is important for us to see is this legislation allows police custody remand to be taken up till 40 days and up till 60 days, depending on the nature of the offense. What does that mean for an individual? That means that bail is theoretical. Practically, you will not get bail for 40 days or 60 days. In my mind, that is a serious curtailment of the right to liberty. And that's actually taking these provisions in the CRPC, which apply to non-serious offenses, as you may call them. That is to say, not that murder and all is not serious, but offenses against the state, for example, UAPA, NDPS, that's Unlawful Activities Act, Narcotics Act, and organized crime. Those offenses, those statutes allow for larger periods of police custody. Now, we've not extended the period beyond 15 days, but we've definitely allowed the police to take police custody, though for 15 days, either over a period of 40 days or 60 days. Practically speaking, that's a negation of the right to bail, that's a negation of the right to liberty.
So you're absolutely right that, courts do take very different views on the question of bail between benches of the Supreme Court, lower courts, high courts, often different interpretations that have been taken. So would you like amendments to come in these bills which would codify what the Supreme Court has often had to say on the subject of bail, that, unless there's some very specific reasons, bail should be the norm? Would you like to see that actually put into these Sanhitas?
Myself, the First Amendment I want before a codification of the law on bail, the First Amendment that I seek is a restriction on the right to arrest. Why arrest? The Constitution bench in Sushila Agarwal says a recovery made even in an anticipatory bail order is good enough. But in India, the problem is once arrest happens, and Vikram, I must blame some of you and your friends also for this. Once an offense is registered, a lot of people start baying for the blood of the person who's accused of an offense and saying, why is arrest not happening? So what do? You tell me.
Okay. In my own personal defense, I have very strong views on individual liberty, so I don't think I've ever exactly done that. But
I think people in your line of work say, don't they? And I'll tell you this, practically speaking, I've appeared in trial courts and even in the High Court, and, judges have often had an off-the-cuff remark. I hope they're not influenced, but they often had an off-the-cuff remark. Isn't this the case we read about in the newspaper? And there are specialists in the police department who let out these morning press releases or the night before press releases, which are splashed all over the paper the day a matter comes up for hearing for bail.
Okay, so issue number one, the question of arrest and bail, and how does that get codified into the new laws? And the second question is the entire concept of speedy justice. And this is something which even Home Minister Amit Shah and the Prime Minister referred to repeatedly, including by introducing the bills. And let's face it, this is a really important question. Those prolonged delays we see in India, 10 years, 50 years, 20 years, case chala ja raha hai. It's actually good for somebody who's guilty because punishment is deferred, and who knows, perhaps that person can get himself or herself off maybe by paying something under the table. But it's terrible for somebody who's a victim. That victim doesn't get justice. It's terrible for someone who's innocent because you can have a sword hanging over your head. You could be in prison. You may be under trial. And even if you're not, you're facing with an accusation that is hanging over you for years altogether. And then 20 years or 10 years later, you get acquitted. This is not correct.
Understand, everybody has the right of presumption of innocence. I must clarify, nobody is guilty to start with. The court has, you have to have a process. And you're right, delay often inures to the benefit of an accused. Having said that, we must understand one thing. 1898 Code, 1973 Code, all said trial must be done day to day. The one state where sessions trials happen day to day are, I believe, Kerala, where after the charge is framed, the matter is put down for trial, maybe a year and a half later, and then the trial actually goes on day to day. So two things. You can add as many procedures as you want. We don't have the manpower on the ground. We have not been able to achieve the 2012-13 recommendation of the Supreme Court to say have at least 50 judges per 10 lakh population. We've just not been able to do that. We say we brought it to 20, but the population has gone up, number one. Number two, we don't have the infrastructure. And let me give you an example of how it works. 75% of your high court positions are filled. 25% approximately are vacant. Similar is the position of the trial courts. We just don't have enough people, and the numbers have risen. In fact, in COVID alone, 2.5 years of COVID, we've had a 1 crore backlog added in cases.
So I just wanted to ask you a specific question when it comes to speedy justice. A lot of talk and headlines have been there about the new bills and the provision that a charge sheet has to be filed within X number of days, framing of charges that has to happen within X number of days, and then a trial. One of the questions that I think is somewhat unclear is what happens if that process doesn't happen? What if the charge sheet is not filed? What if the charges aren't framed in that much time? What happens?
The default bail is the consequence that was there in the early 1898 code, in the 73 code, and is there also now.
But that's only when someone's actually been arrested, then the question of default bail comes up. What if somebody's not been arrested, but charges have not been filed or charges are not being framed in the specific time? What happens then after that?
I'll tell you what, the time periods have been prescribed, but today there are the mechanism that needs to be addressed is charge sheets may be filed, but matters are pending for further investigation, which may be lingering for decades, for a decade perhaps. The Supreme Court had tried to correct this in Vinu Bhai's case to say you can't start the framing of charge till all the investigation is over. But that is followed in the breach constantly. And unfortunately, till we curtail the practice of filing inchoate charge sheets, and this is happening all the time. So in order to fulfill the mandate of the law, an inchoate charge sheet is filed. Let's say in in a narcotics act, you file a charge sheet without the forensic report, which says it's a drug or a contraband. What use is it? And the Supreme Court is dealing with that issue even today. So till we address the issue that investigations must be comprehensive, not just formally complete, we will still continue to have the problem. So the change that is suggested is the way forward, but we will have to add substance to the provisions that have been brought in.
Now, Mr. Luthra, the other way to look at what you're talking about, the question of pendency of cases, because if that backlog doesn't go away, then it'll take, no matter how good your laws going forward are, if that backlog is still there, justice will be slowed down. So is there a time for some sort of a one-time audit or a waiver scheme? I mean, industry, for example, has been calling a lot about for a statute of limitations. If 10 years have passed or 15 years have passed, some old cases are lying around, close them and move on. Don't just leave them sitting around. Is that the sort of solution you think we need to think about as a creative answer to what we are facing?
So there are existing provisions where there are restrictions till when charge sheets can be filed. In certain offences can be filed till 3 years and not beyond. However, for offences punishable with more than 3 years imprisonment, there is no restriction till when charge sheets or investigations can be concluded. Thirdly, there is a 1974 law called the Economic Offences Inapplicability of Limitation Act, which allows certain statute, let's say Customs Act, etc., where there is no statute of limitation.
But isn't that the most obvious change to bring? One simple change, get a statute of limitations on all of that, introduce a statute of limitations that after 10 years or 8 years or something, those cases fall away. Half your cases will go, your pendency will come down, and justice can be speeded up.
Are absolutely right. The Supreme Court sought to do this in 1996 and 98 through the common cause judgments, and then realized that they could not do it. And 7 judges in 2002 said, we can't bring in these legislatively judicially mandated guidelines or timelines. Parliament had to do this. That was 2002. We're in 2023.
All right, well, Parliament is now actually changing all these laws, so maybe that's something to consider. One simple change, and the other changes that we've been discussed, which can make 30-40% of cases just disappear and move on. Now, one last thing that I'm just going to discuss. There are lots of things to discuss on these bills, women's rights and others. I'll do them in subsequent weeks. But staying with the question of individual liberty and liberty-oriented issues, the entire question of special acts that actually exist, right? We've seen a lot of debate on sedition, which has been there, so I'm not going to reprise all of that once again right now. But a lot of people are also saying, what is the point of having an IPC that protects individual liberties if you then have 7 or 8 special laws from narcotics to UAPA to PMLA to what have you, and if you can arrest somebody under those and lock that person up for 3 years or 4 years for a cheating offence or for other offences. So do you think somehow those laws now need to be brought into consonance with what is sought to be done with the criminal laws?
So the catch here is, Vikram, we've actually introduced to the new law offences of terrorism, offences of organized crime, offences of corruption back into the statute. And we've not repealed those statutes. So we're going to have a situation which is going to create a dichotomy. Those statutes have reverse burdens of evidence. This Evidence Act does not. Until you amend those or recall or repeal those statutes, you have now 2 sets of provisions attacking the same crime. And that is a problem that will need to be addressed, and I hope it's addressed by the Standing Committee.
That's actually a very important point you're making, and that is again a very important thing that can be done right now, because it's there in the Evidence Act, for example. You can now put a lot of these into these bills and these criminal bills, so it is one set of laws, and then you can repeal all those other 10, 20, 30 laws that are floating around and say it's all covered by one particular set of laws that will govern all of it.
So my dream code, which I would have expected would be on the US lines, where all the central government legislation, all the union government legislations on criminality would be in one book, all the Evidence Act provisions in one book, and the procedural laws in one book. The reason is this. Look at the hapless sub-inspector or the head constable that has to go and look at different books to find which law does he apply on the same set of facts. And that is the reason you have procedural infirmities and prosecutions fail. So if you actually bring about those comprehensive laws, it's a win-win situation for the justice system, which becomes effective and faster, for the judges who have to adjudicate, for the lawyers, accuse and defense, prosecution and defense who have to adjudicate, and for the investigator. Today, the problem is there may be an offense, let's say mischief under the IPC, but it may also be an offense of felling of a tree under the Trees Act. Where all does the investigator go, or the Environment Pollution Act?
Right, Mr. Luthra, I think we could go on and on, but we're going to have to leave it there for a moment. But hopefully this is a debate that will continue. Are you at the end of the day, though, optimistic? Because the fact that these three bills have come mean that there is that opportunity to have big bang reform and big bang change. I know in my entire career as a journalist, I've been hoping for changes in some of these things. I'm sure in your career as a criminal lawyer, you've also been hoping for the same thing. So a chance to get things put right now?
I think it's a step forward. And we should always welcome steps forward. But having said that, there are miles to go before we sleep.
Sidharth Luthra, thank you so much for joining us. So potentially big bang reforms coming in India. But as he was just saying, this will have to be debated, discussed, analyzed, maybe amended, maybe tweaked. But if the criminal judicial system in India can be fixed, and the judicial system in general in India can be fixed, it goes a long, long way in moving the India story forward.